Um, Hello, everyone. It's 12 o'clock, and thanks for joining into our webinar today. Just give us a minute, just so that we know there's a number of people trying to log on. So we'll get started in a couple of minutes. Thanks, Yasha. Okay, sorry, I'm just trying to figure out something here from a tech perspective. I will be right back. I'm just going to mute this very quickly. Okay, sorry about that. And now we're ready to get started. All tech issues resolved. So thanks for joining us today. And we want to talk about, the new normal, or well, might be normal, or there might be changes. But for now, it is virtual court. That's basically what's happening, at least in most of the courthouses around the GTA. And Anisa Dattu is going to be running this webinar because she has a lot of experience dealing with virtual courts. So for those that don't know Anisa, she's a family law lawyer at our firm. Anisa has several years of experience, both from her days as an intern to an articling student and family law lawyer. She's very passionate about what she does, and her numerous Google reviews could attest to the great job that she does for her clients and the extent of her knowledge. So with COVID-19, obviously everything's changed and the courts had to adapt as well. And the reality now is most court attendances are being done virtually, and that includes conferences and motions. So it's been a game changer, and even for the lawyers, it's just been a learning curve for all of us because it's all new. So Anisa has had a lot of these appearances, and she's going to be sharing tips and tricks that can help you if you're self-representing, or even if you're being represented by counsel, at least give you an idea of what we're doing so that you could kind of follow with the process and understand what's going on. So I will pass it on now to Anisa. Anisa, I'll just let you run with it. We have a number of questions already. So when you're done, I will go over them. I have a feeling that you may touch on some, but we'll see at the end. And I would also monitor the chats to see if there's any questions coming in. On your screen somewhere, for those new to Zoom, either at the bottom or on the side, there will be a Q&A, I guess, what I say, bubbles. And you could just click on those, type in your questions, I'll monitor them, and I'll have Anisa respond at the end. And without further ado, Anisa, could you please share some tips and tricks on how we can conduct our virtual court appearances?
Thank you so much, Angela. And good afternoon, everyone. Thank you so much for joining us today for our webinar. I know that it's the end of the month and usually a busy time for everyone, but now we're in the middle of a pandemic. So what are we doing and how are we coping with the court system? Many of you may know, or maybe many of you have already been affected by the fact that the courts were working on a very limited schedule at the beginning of the pandemic, which has caused a lot of court attendances to be adjourned to the last few months and currently still ongoing until the end of the year, which is why I'm able to speak to you guys today about tips and tricks on virtual conferences and motions, because I had so many sandwiched between, I would say, even August to now, and even, more litigation than I would do normally in a few months, because all of my appearances from March were mixed with all my appearances that were already scheduled for this time as well. So the new normal, as Angela had said, is here upon us. And what do we do about it? So some of you may already know, and the good thing is we're using a platform right now called Zoom. And for all of our attendees, you guys are already halfway there because you guys managed to log online to join our webinar. Now, I'm hoping that you saw that it was easy because a lot of the courts, especially the Superior Court of Justices, they're using Zoom to do their conferences. That goes for case conference, settlement conference, trial management conference, and even motions. Okay, they're doing a lot of their conferences via Zoom because it's a face-to-face way to interact, to see everyone. It's easy now it's generally easier for people to use compared to other web platforms. It's a little secure as well. And it's something that the judge can actually see, and it can be used remotely for so many people. I've had people, I've had some self-represented litigants literally take the call, literally take the Zoom conference call in their car. So you can see them in their car, because for them, that's what is appropriate. The courts know that that this is an adjustment for everyone. So these tips and tricks that I want to share with you today is to kind of put your mind at ease, and also let you know that it's not as different from being in court, but obviously it's something to adjust to. And doing Zoom conferences and virtual court, I should say, because it's not only via Zoom, but doing virtual court now for a few months, I really like it. I definitely have some dislikes as well, and I'll share that. But on the general kind of progressive notion of where the world is going and how family court can now be more easily accessed, I'm loving that. I'm loving that aspect of it. So let's start off with a few things. And I think my first question to all of you is, do you know how to use Zoom? The fact that you're here shows me that you're at least comfortable with the platform and what it is. And what my first tip would be is, if you've never used Zoom, maybe other than a webinar, and if you really want to do kind of that one-on-one, then I would say practice a few days in advance. Download Zoom. There are different ways to access Zoom. You can do it from your desktop. You can download the app. I always say download the app so that it's more reliable. You can download it on your computer. You can download it on your iPad, your tablet, your cell phone. I have Zoom literally ready on every device that I own, because if I'm in court, I want to make sure that if something happens, because technology issues are real, guys, if I have any issue, I can just move to the next one and access it, and I'll be right back on. And you want to make sure when you're on Zoom that you know where your mute button is, you know where your video button is, you know where the chat button is as well. Those three, I would say, are very important. The mute button for obvious reasons, because obviously life is around us. If you're doing Zoom from home, and a lot of my clients are, they're at home or they're in their workplace, sometimes they're in their car, wherever they can get a little quiet, private area. No one's going to judge you on the area that you're in. I mean, let's be honest, maybe sometimes, right? But for the most part, if you have to go to your car, the judge isn't going to be mad about that, oh, you're homeless, you have nowhere in your house. We know that, you know, your dogs are barking. We know that your babies are crying. We know that there are other people in your household working from home as well. We know that, you know, maybe there's a caregiver in your house or something like that, right? Or in your small apartment. It doesn't matter. You know, I've also had people sit on their bed and do it. And they've apologized to the court, and the judges have been more than welcoming to say, you know what, but you're here, you're present. My big tip would be, you know, maybe a few days in advance or even the morning of, find a quiet place. Even if it's just, you're seeing just the screen that we're in right now, you're only seeing my top up. So you want to find a quiet place that has that kind of background that you can work with. Something that's not distracting, maybe something that's not with a TV in the background that's on, something where you don't see other people is really important, because it is distracting. When we're physically present in court, you know, and if you've ever been in court in front of a judge, even sometimes the slightest head movements, the judges will call you out on it. So if they can see all of that while you're physically in front of them in court, you better know that they're going to see it when you're on Zoom and they can see everyone very clearly. It's only a few people for them to see. In your Zoom conference, you're going to have the judge, you're going to have the other party, maybe their lawyer, if there's a lawyer present, you're going to have the registrar and the court reporter. And then of course yourself and your lawyer if you have one, okay? So you're going to have about anywhere between, you know, maybe 4 to 6 people. So you're going to see different bubbles. A lot of the times the registrar and the court reporter don't turn their video on, so it's less distracting. You're only seeing the other parties, the lawyers and the judge. So you're focusing on that. There are different ways, and it's more just getting comfortable with it. Plan a day with your siblings or your friends or, you know, some family members, and try to do maybe a little kind of Zoom experiment so you're comfortable with using the mute button, because you're going to want to mute yourself. A lot of the times the court registrar is managing different buttons and they're trying to mute you when it's not your time to speak. And they want your video to be on usually. I've had conferences where some parties haven't actually had their video present. It's not something that we encourage. It's not something that is encouraged. You know, they do want your video to be present. It kind of makes it as normal as possible for face-to-face interaction, because if we needed to be present in court, obviously the court's seeing you. And as a family law lawyer, I always tell my clients, I want you to be present. I want you to be present verbally and physically as much as possible. So that means put your video on. There are different options. I give different options to my clients if they want to come to my office and sit in a different boardroom with their device. They can do that. We're still separate. We're still social distancing, or you can do it from home. Or if you're unable, the beautiful part is that maybe, you know, you're working in an office or you're working somewhere and you're not working remotely anymore. And previously you would have taken off maybe a full day or a half a day to attend court. But now one of the big pros is that you don't need to, because a lot of the times, we need you present on video. You can sometimes do that with your, being at work sometimes. We do want your full attention, so just understand that. But if you're able to be a little flexible, then you don't have to lose that time or that income or, a day off or anything like that. So that's wonderful. One of the biggest changes, and if you've been in court before, sometimes you'll notice that, either you're waiting for a really long time, or you're there for a long time, maybe working on a consent or an agreement, or the judges are running behind. I've noticed that time punctuality has been of high importance with virtual conferences. And if I'm supposed to be on at 9:30, I'm on at 9:30. If I have a conference at 10:30, usually I'm on at 10:30. The ones I've noticed that are usually a little bit more delayed are 11:30 appearances and after lunch, but I'm not talking by a lot of time, maybe 5-10 minutes maximum. A lot of the times I log on about 10-15 minutes in advance, and I would suggest for you guys to do that as well. You don't want to log on too early because you'll just be in a waiting room. You'll get anxious, okay? 10-15 minutes in advance, just like if you're going for a job interview, right? You don't want to show up too early. If you have a lawyer, your lawyer will also tell you their preferences, okay? These are just my tips and tricks for you. But you'll be in a waiting room, and the court registrar will be doing their job to make sure everyone has shown up before they bring the judge in, okay? And you'll know sooner or later, if you're in the waiting room, know that just because your video is not on or anything, it can turn on at any point. So you want to be careful with what you're saying. You want to already be in your quiet space. You want to be dressed for success. You want to be, I've had clients literally say, Anisa, I'm wearing a suit, but I'm wearing shorts. Or, I put a blouse on, but I'm in my pajamas. That's okay. I don't care. It's just top up. So you want to be presentful. You want to be presented well. I mean, you don't want to just roll out of bed, obviously, but you want to, the same thing like court, treat it as much as possible like you are going to court. So you still get that same feeling. One of the biggest, concerns that I had before virtual conferences became as normal as they are now is, my clients are not going to kind of feel that same impact of being in court and kind of that impeding feeling that, oh, I'm walking into a courtroom, I'm before a judge. It's obviously a different kind of experience, but the judges and the courts have made it as real as possible, and given the circumstances, as real as possible. Initially, there wasn't such a big reception, warm reception to virtual conferences. And there are some cases that, where the parties had opposed attending via virtually. And, the policy arguments for those who are against video conferences or virtual conferences, I should say, are not actually matters that the courts are giving any type of response on, unless they think you absolutely have to be physically present. So unless, you have to be physically present because of maybe a disability or, no access to the internet or anything like that, the courts would maybe entertain having you in person, but for an overall safety aspect, because even a lot of the times the judges, they're not even in court. You'll see them with maybe a virtual background of the court behind them. Maybe you'll see them at their dining room table. You'll see them in their home office. You'll see them in their chambers. You're not seeing them in the courtroom. Sometimes they're robed, sometimes they're not robed. So you're seeing a different variety of how everyone is accessing the new normal of family courts. And it's up to you to make sure, can you do it or not? Because chances are most of the matters are going to be proceeding virtually and not in person, at least not yet. So if you're opposed for any reason, and I've seen cases where one of the parties was opposed because they think that virtual court cannot address the situation properly, and that information is going to be perhaps lost in the video conference. And the court said, no, like, why would it be lost, right? Let's see it, because, if we say that only your matter should be exempted, then all the other matters should be exempted too. It's something that we are working with. And I actually prefer it in the sense that I feel like you're actually being looked at, you're actually being heard sometimes. One of the biggest things is, there's some etiquette. And I want to talk to you about the etiquette and be very touch base on, using your mute button and making sure, you don't have loud noise or music in the background. Sometimes the judges will tell you, can you move somewhere else? It's a little loud. The other point is not to talk over somebody else. It's a very It's very respectful. Like I said, the court registrar may mute you. So for you to go and, put your unmute button, it's for you to go and click your unmute button so you can talk over someone, usually isn't tolerated. Let them finish. You'll have your chance to speak, or let the judge know. I've actually seen the judges be a little bit more accommodating to having to hear what people have to say. And that goes for clients, for lawyers, self-reps. They're a little bit more accommodating, but they are staying true to their time. So for example, if you're scheduled for a 30-minute conference, they are staying true to their 30-minute conference. If you're scheduled for a 1-hour conference, you'll see the judges, they're able to wrap it up in an hour, which is different from when we were physically in court, right? Sometimes we'd be in for 20 minutes, go out, try to work on a consent, go back in for another 20 minutes, that back and forth. And somehow 6 hours has lapsed, right? We don't know where the time went, but it's different with Zoom. Now, is that part lost in our family justice system? No, it's not. Is it something that I think still needs some work? I do, because, as lawyers, we didn't realize that those 10, 15-minute hallway conversations that we like to call it, between court, we didn't realize how much value those had to benefiting a matter sometimes. So now it's a little bit more effort that we have to do to maybe pick up the phone and call the opposing counsel, or get the registrar to say, to put us into a meeting room, or a breakout room so we can discuss it. Sometimes the judges will say, I think there's potential for you guys to settle this. I'm going to put you in a breakout room to discuss. Are you agreeable? I mean, yeah, why not, right? Because that's the purpose of these conferences, right? And so you get put out in a breakout room, and then sometimes they'll pull you back, and they'll say, we'll pull you back in after the next matter, because like I said, they're on a schedule. So then they'll pull you back in, for example, 30 minutes later, just for an update. And they'll leave you in the breakout room as long as you need for the most part. I've experienced that. And then you let them know. If you're unable to settle things, I mean, it is what it is. But sometimes when you are able to settle things, especially if there are lawyers, I think there's a big benefit in having 2 lawyers in a Zoom conference sometimes, because at least they know how to get things in quickly in terms of procedure. But there are different ways, one of the biggest things is, I would say, if you don't have a lawyer and you are in a Zoom conference or anything like that, get the registrar's email address. When you're starting off, or if the judge says, oh, you can email my clerk or anything like that, get their email address. Ask for it right then and there, because that's something you can easily forget. Only after the matter has ended, then you're like, wait, I know I have to email something, or, vice versa. Get the email address. A lot of the times they're pretty diligent, and they'll actually send it to us via chat right away. So if we have to send in, for example, a support deduction order or something like that, a lot of the times the clerks and the registrars are saying, we just want to interrupt the matter and just let counsel know that we've sent our email address, because there are so many, right? Who are you going to track down? So that's really helpful. And that's why I said, be familiar with the chat button. Okay. Also with the chat button, you can sometimes privately message your lawyer. You can sometimes privately message the court. I'm not saying to send a message to the judge saying, she's a total liar, nothing like that, but procedurally, right? You want to be respectful. There's a big element of respect when we're dealing with things like this. But if there are procedural issues that, you really kind of need satisfied, then sometimes you can send that message and make sure that they know that, you have this question or something like that. Not specific to your matter though. Just remember that procedurally, yes, if you're talking to the registrar, I'll send the support deduction order or something, but not like, hey, I want to talk about my spousal support claim, or I want to talk about parenting or something like that. Nothing like that. Okay, guys? For motions, what's really important for lawyers is that you don't have to be roped. So again, there's a little informal aspect about motions in court, and you don't have to be roped. And a lot of the times, it was actually surprising for me to see that judges weren't roped either. And in a way, I actually really kind of like that direct impact sometimes that you get, because you literally see the judge, and you see all their reactions. It's very clear. It's very clear. And in a way, you have your table. You have everything set out. Everything can come to you, right? So you're not really scrambling. You're in your own comfortable zone. So in a way, that's a big advantage of virtual court. There is some courts don't use Zoom. And I've noticed that a lot of times with the Ontario courts, so the Ontario Courts of Justice. So there's SCJ and there's OCJ. The OCJs, I've noticed, have been using teleconferences. And that's as easy as calling into a line and punching in your unique access code. And you're on a teleconference court. So the judge is there, Madam Registrar is there, the court clerk is there, the reporter is there, everyone's there. The same thing as Zoom. The only thing is you're on the phone. So that's another way of accessing virtual court. And in particular, I prefer Zoom just because I like the face-to-face interaction. But this is another way that that conferences and motions are being heard right now, and that's through the phone. So you're calling, and again, you want to make sure you're in a quiet place. This time, it doesn't matter what you look like or where you are, but you want to make sure wherever you are, quiet place, good cell phone reception, and that you can actually hear them. And if you can't, let them know. The big thing about virtual conferences, though, guys, is you're not trying to talk over each other, because it's very easy to talk over each other and for things to get lost. You're on a time crunch to make sure that your matter is heard. So you want to make sure that that you're not talking over each other. And a lot of the times the judges will tell you, sometimes I actually recently had a conference where I don't know what happened, but I wasn't able to hear what was going on, right? Technological problems it's a reality now. And the other lawyer, her call kept dropping. So it is what it is. We were having some issues. Even the judge was having some issues hearing us. And it was extremely frustrating. We got through the matter, but it was extremely frustrating. And, it was something that we have to work towards better for the next time. But things like that happen, right? It's not that, every day is going to, you're going to have more successful days, but there could just be that one day where your internet is really spotty. Your cell phone connection is really bad. Just recently, I'm not sure if you guys heard, but there was a lot of noise with some of the cars in the background just now. So, there are things like that you need to be aware of. But you want to make sure that with Zoom conferences that you understand that they're still going to treat it in the same manner as when you're in court. So it's not that you can unmute yourself anytime or anything like that. The applicant still has their chance to speak. The respondent still has their chance to speak. The judge needs time to give their views from the bench as well, okay? And one of the biggest things that I do want to stress is, your etiquette and the decorum that you're in is a really big deal. And that for the most part, this is one of our realities. It's one of our realities in terms of accessing court virtually, whether it's through Zoom, whether it's through the phone, and you want to make sure that you're open to that, because your particular matter may not be something that the judge is going to say, why don't you come on into my courtroom? Because a lot of times they're not there either. Okay. With the new world that we're in, with the new virtual family law world that we're in, another big thing is getting your materials in virtually as well. I'm not going to touch base on that too much, but I do want to say that, the same way that hearings and motions are online and everything, the same thing it goes for filing your pleadings, your conference briefs, your 17F confirmations, your 14C confirmations for motions. There are email addresses, particular court email addresses to send those to, file them. There's another new initiative called case lines that some of the courts are using. So it's important to make sure you're educated on this and not the night before. You want to do this weeks in advance. Find out what's required of you, because just because we're online now doesn't mean that the whole procedure and everything is thrown out the window. It's not. We're still following the particular rules and procedures to make sure that things can go as smoothly as possible. And a lot of the times, your virtual conference or your virtual motion is only going to go as smoothly as you've prepared it, right? Like I said, we're on a time crunch. If you're not sending in your 17F and apprising the court of what your issues are you attending, how long you think you'll need, they're not going to schedule you properly. And in a way, if you need more time, they're going to say, well, your 17F only said you needed 10 minutes. So, for you to want to talk for another 30, 40 minutes, it's not something we're scheduled for. So you want to be careful about things like that. So I think for the most part, that was kind of my general outline. And what I want to do is, I've seen so many questions come in. I know we had some questions in advance. And I think if I haven't answered anything, let's start a discussion about the questions that you guys have, because some of them are really interesting.
Yes, Anisa, I will take it from there. So I see, okay, so I guess the first one is, do you need both parties to consent before you could do this? So do both parties need to consent to virtual court, or is it just a matter of course, does the court decide?
No, so the court has decided, and it's not actually the court that's decided. There's a case about this too. This is a province-wide effect that's in response to the pandemic. So any concerns or anything like that, are actually for the Office of the Chief Justice and not for individual judges or courts. So if you have a big problem with it, you need to take it to the big guys, and the court's out of power in that one.
Okay. And are these virtual appearances being recorded? Can they be used as transcripts?
No, so that's a really good question. So you're not supposed to have anyone else in the room with you. You're not supposed to record, and you're not going to get the transcript. If it's a motion, that's different. Motions are on the record, but conferences are not. If the court is recording it for their own records, I'm not sure if they are, I don't think so, but if they are being recorded for their own records, it's for their own records. But no, it's not something, the same way normal court goes in terms of conferences being off the record, the same thing applies here. But for motions, yes, they will be on the record, and you should be able to get transcripts for that, but you will not get the recording. And it's highly inappropriate as well for you to record it yourself by any means, just like you're in normal court.
Okay, so, and then someone asked that and this is an earlier question we had received, that they are self-represented and would like to share documents on their computer. So is screen sharing allowed? I know that's something that we could do through Zoom. Is that something that would be allowed in virtual court?
No, so they're not allowing screen sharing. Okay. Because what it is that your material should be in by the prescribed timelines in advance. Okay, so you want to make sure that your briefs, your motion affidavits, anything like that are served and filed in advance. Guys, there's no surprises, right? When it comes to these court dates, the judge needs to know everything you're relying on. So if you have something that you feel the need to screen share, include it with your brief or your affidavit or anything that you're filing in advance. To kind of show it in advance. I know that sometimes there are those documents that we don't always have prepared, and that's fine. But for the most part, the courts wouldn't necessarily tolerate a screen sharing. It's more, send it to my clerk after the appearance and I'll look at it. Or if you have it here, read it off, kind of like how we do in normal court. The only difference is we can't pass it up in the middle. So it would be something kind of an afterthought.
Okay. And are there limits on the materials that you can use at virtual court? And maybe we should backtrack a little bit. How do you even get these materials to a court? Because I know, lawyers, we know what we need to do here, but for a self-represented person that's just getting started, they need to start their application today. Where do they go from here? Where do they start?
Good question. Okay, so how do you start? If you're a self-represented person, where do you go? So my first tip to you would be to find the specific court that you're going to be dealing with. So for example, if it's Oshawa or Toronto or North York, you want to find their practice direction and their guidance, because they've all been updated specific to what they're expecting for virtual family law right now. And like I said before, there's virtual filing. So there's virtual serving, there's virtual filing via email, and serving via email and stuff like that. So, you want to make sure that how you're able to effectively serve and file. A lot of the courts have specific email addresses that they are accepting your materials for filing with a proof of service after you've served it. And then there's also, like I said, there's also the new project called Case Lines, which sooner or later should be affecting all courts, but it's more or less an online portal. update your documents to, and that's really great. So you want to find out if the court that you're dealing with specifically has guidance for using case lines, or they have the email addresses that you're sending it to, because they haven't started that project yet. But you want to become familiar with that. If you're unable to find it, and it's an easy Google search, but if you're unable to find it, call the courts. Call the court, say, I can't find the guidance here. Can you email it to me, or can you tell me where I should go? And then they'll be more than willing to help. Or a lot of the times, you may have to leave a voicemail, they'll call you back or something like that. There are limits though. So there are limits to how much you can file. And it depends on the court. Sometimes it's 6 pages, sometimes it's 10 pages. But you do have to be very careful because it's virtual, it's not the same capacity where the judge is literally getting all your pleadings and being able to flip through every page. It's not like that anymore. They're looking at it virtually. If they print it off, that's their choice. But for the most part, they're getting all this virtually. So they're not trying to have too much that they have to review virtually, especially because they're reviewing a lot at home. And there are restrictions. And for the most part, most matters can easily get all their points across in those restrictions, and you're able to attach documents, you're able to attach, maybe medical evidence, whatever you want to attach to it, you're able to do that as well.
Okay. So your application's issued, and I'm taking it that to get your application issued and all of that, you just have to do a simple Google search of the courts and get their direction, and that would sort of guide you through. Or if you want to be bold and call the trial coordinator's office, I'm pretty sure they don't like that, but as a last resort, that's something that you could do if you're self-represented. Lawyers, please don't do that to them. But just look at the practice direction. Yeah. Okay. So for conferences and motions, I know back in the old days, pre-COVID, you needed consent to be able to serve by email. What's the situation now? Are you able to serve your conference and motion materials by email? And do you need the other side's consent to do that?
Yes. So now service via email is widely accepted. You don't need to get their consent anymore.
Okay. So that's great. That's very convenient. So that's one good thing out of COVID. So just looking through some other questions here. Someone said, can I still go in person? The answer, I'm guessing that's an easy one. It's probably a no. You would have to get a specific order to be able to do that. There's no one there for the most part. Okay. And someone asks, how do I get the phone number or Zoom link for my court date?
Another really good question. So usually the court will send it to you via email. So your pleadings should have an email on them. Okay. So when you're filing, you should have your email address where all of your information is. If for whatever reason you don't have your email address there, usually the courts are trying to call you to get an email address. Right now, they actually have no tolerance. They want email addresses. Even if you have a lawyer, they want the parties' email addresses as well on the material. So that just in case there's a tech issue, and for whatever reason the lawyers the Zoom link went into the lawyer spam, their client received it, because it's a reality of the system right now. So you want to put your email address on all the pleadings, and you want to generally check this email. It's not just an email just for court. You want to check your email every day. If you have a court appearance coming up, and perhaps it's the day before and you still haven't received anything, then you want to call the courts and you want to let them know that I haven't received anything. But usually at least a few days before. I know earlier on I was receiving Zoom links sometimes the morning of, but literally, or the night before. Usually right now they're kind of more streamlined and they're sending things in advance. So, just check. They might have sent it to you a month ago or a week ago or even a day ago.
Wow. So there's really, that was the next question. How soon? So literally, even if you don't get your Zoom link the night before, no panic. Your court date might still be happening. Just be up bright and early and check your email, I guess, is the.
I guess so. I would say, right now, if you haven't received it by the night before, then, I would say you want to make sure first thing in the morning, you want to call the courts and find out. Okay. but you know, it's not uncommon for you to get a link maybe the day before. Right now, they're just a lot more. The courts are very organized right now in terms of getting the links out. But yeah, are there maybe some matters that, you know, have been recently scheduled or something like that, and they still need a Zoom link for, or have been overlooked? Definitely.
Okay. And someone says, how do I know if I'll get Zoom or telephone call? So I think I want to probably even expand that to say, do we have a choice? Do the parties in the matter have a choice of whether it's a phone call or Zoom?
No, so usually the parties don't have a choice. It usually depends on the court. So like I said, you know, dealing with the Superior Court of Justice, most of them they're all using Zoom. Most of them, at least the ones that I've dealt with. All the Ontario Courts of Justice that I've dealt with are all using teleconferences. So it looks like it's court specific. If for whatever reason, you know, you want to switch to a teleconference, I mean, you'd have to apply to the court to ask them, but there have to be some type of exceptional circumstances that you're not able to access Zoom. But guys, one of the great things about Zoom is that it doesn't always have to be through an internet connection. A lot of the times the information you get, there is a dial-in number as well. So if you're unable, and that's why, you know, a lot of the times when people are sending in requests, you know, they're getting rejected because, you know, you can call, you don't have to be there. You don't have to virtually use Zoom in terms of using it on your computer. You can call into one of the numbers, but I don't suggest that, because if everyone is there physically and you're on the phone, I mean, I prefer a certain element in seeing things kind of unfold and seeing the judge. If you're on the phone, you're not seeing them, they're not seeing you. You may be a little lost. So I don't prefer it, but if that's what you have to do, then that's what you have to do, and that's fine.
And how do you handle sort of that loss of control? Because we've all had that experience where when you're in physical court, and we've done that for way too long, you can easily, you could tap your client, and you do it with your body language or slip a note and things like that to sort of control the either the behavior of your client, their expression, or sort of stop them if you think they're going to find a response that they're given. Just little things like that. How have you been able to manage that so far in virtual court? Because you're not even in the same room with your client.
Yeah, you're not in the same room. I mean, sometimes it's not easy, but you know, you want to have a conversation. Like I always have a conversation with my client, even the day before, sometimes the morning of, and I let them know that, you know, now we're in virtual court, and I call it the poker face. Because they can see you, the judges can see you, and just, I'll give you an example. About a week ago, I was, you know, in a Zoom conference, and as soon as my client nodded her head, the judge straight away said, "Dad, see, mom's nodding her head. She's agreeing." And I was like, whoa, that was quick. That was really quick.
Exactly.
So, you know, and I told my client before too, and I said, poker face, you know, just like you're in court, you know, you don't want to necessarily show your emotion unless you absolutely can't help it, right? But you want to have a certain decorum, you know, you don't want to sit there when the other person's talking and be like, no, 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 it's going to annoy the judge. You want to, you know, still be respectful. And it's a level of maturity too. Um, you want to also, you know, even the chat, sometimes, you know, I've used the chat to kind of reach out to my client, and I've told them, you know, like poker face or something like that. Nothing stops you from being able to still kind of reach your client by another means if necessary. But sometimes, you know, you also don't want to look distracted, right? The big thing is the courts will see if you're distracted, and you don't want to look distracted. You only have a limited amount of time. But also, you know, if I have a client that's speaking, and you know, they're going on rambling, and then they're going on, then, you know, sometimes then I'll unmute myself, and I'll interject if I have to.
Okay. Okay. And I think that does a lot of it. Thank you so much, Anisa. The last one we have, I'm not sure if it's necessarily on topic, but it's still related to how we're just living, a virtual life now. And that's swearing of affidavits virtually. So I guess that's the new reality now. And it's now part of the act, right? You're able to, it's now the law. It was a problem before, it had to be sworn physically in front of us. But now, if you need to get that motion sworn, you can do it via Zoom as well, right?
Mm-hmm. Yeah, absolutely. Zoom is not only just for courts, it's also a new way that as lawyers, we're commissioning documents. and we're swearing documents. It's something that since the pandemic we've been allowed to do, so that we're avoiding that in-person contact that we initially had to have to sign documents. And if you're a litigant in court, you know that you've had to find a commissioner or a lawyer or something to commission and swear all your documents, whether it's a financial statement or an affidavit or anything. So those are things that we're able to now sign virtually, which is a big time saver, a big paper saver sometimes too, which is great. And something that's just, I think this is something that, we've just been waiting for a really long time. I really like that.
Okay. So I have another question here. Sorry, I just thought we were almost done, but looks like there's a couple more. Okay, this is more of a comment about, I guess this is when we were talking about conduct and being able to control the client with us all being in separate spaces. But the comment says nothing stops the other lawyer texting answers to them. I mean, you could, but at the same time, I think that's a lot to do. You're trying to be present and get the judges opinions. And I think I want to weigh in on that a little bit, because with conferences, I always tell people to understand that it's a chance to hear the judge's opinion on your matter. It's not that judge is not likely to make, in fact, it's almost 99% they're not making a decision on your case. They are trying to help you narrow the issues and give you a third party perspective on your case. So if there's ever a time where we need to use the principle of 2 ears and 1 mouth, it's during conferences, whether virtual or in court. Listen to the judge when they're disagreeing with your opinion. If you're going to argue with them, it should really be about clarifying where you stand, but not trying to just take what they're saying and go use it and reorganize your position, refocus. Listen to them, because they're giving you a third party perspective and it's invaluable. They're letting you know what they or their colleagues think, and that's just their opinion. It's not, it's not the decision on your matter. So I always say that, and I know it throws people off when they're in a conference and the judge is disagreeing with their position. It's okay. That's the essence of the conference. We can take those comments and go maybe approach, re-strategize on our case. So don't lose that valuable element of a conference by being frustrated that you're not hearing what you want to hear. Just understand that you're getting another perspective. It gives you a chance to re-strategize and present your matter in a way that would, ultimately get you the result that you want. And there was another comment about, what about SRL? I'm not sure.
Self-represented litigant. So I want to actually weigh in on that a little bit as well.
Okay.
So I'm not sure exactly what this comment is referring to in terms of nothing stops the lawyer from texting answers. But if I'm in physical court,
Yes.
a lot of the times, the judges even see, but sometimes I'll be writing something to my client and I'll just, put the paper over and I'll be asking questions or something. Because sometimes we get, bombarded with some answers that we don't know, or some new information or something, and I want to know, and then my client will write back to me. That's a respectful way of trying to be a little efficient in front of the judge. So I'm assuming maybe, the same thing kind of happens. But if you're self-represented, I mean, you don't have, it's one of the benefits of having a lawyer. But no, it's not that, as lawyers, we're sitting there, texting our clients everything to say. Not at all. Not, I don't even think it'd be practical, because, my eyes would be here, I'd be there, the judge would be, somewhere there. You would be able to tell if the lawyer was distracted or anything like that.
And there's really no benefit to it. As I said, it's really not about what the judge at the conference, it's not just about you saying the right things to them. You really want to get that judicial input on your case. Otherwise, you've lost the best part of going to a conference. And the last question I have is, do you offer Zoom sworn documents for self-represented for a fee? You offer, yeah. So would you do, I mean, I could say yes, we would, for a fee, we would do that. And I think I speak for both of us when I say that. It's no different from our practice when it wasn't Zoom. We physically swear documents for our clients, and now we do that over Zoom as well. So the answer to that is yes. And I think that's all for today. Anisa, I don't know if you have any closing comments for us.
I think, guys, it's a reality. It's here for a while. No one knows when COVID's going to end. The courtrooms are doing their best to expand their practices, but for the most part, it's being comfortable with what we have now. If you have a court date coming up, I would say, you want to use these tips and tricks. You want to be comfortable with it. Don't, you want to be open to it, because if you're not open to it, you're gonna preclude yourself from being able to be open to being receptive to what the judge has to say. So you really want to approach this with a grain of salt and know that, right now, are we in a tough time? Yes. And can I do anything about it sometimes? No. But what do I have control of?
All right, on that note, we'll say thanks everyone. Have a fantastic weekend. Safe trick and treating trick or treating for those who are going out. And our next webinar, we look forward to having you guys join us. We'll be talking about child support and undue hardship, because we know that that's something that's very important for people right now. And we'll be discussing the tests and the legalese around child support and undue hardship. So have a good weekend, everyone.
Thank
Bye.
you so much. Bye.